The Data Practices Office is a statewide resource on data practices and the open meeting law. The bulk of what we do is take questions related to those laws from members of the public and government. So please feel free to reach out to us if you would like to discuss a data request or classification, or whether a meeting should be open or closed. We also provide training on different data practices and open meeting law topics. We are hoping to transition our in-person workshops to an online platform this fall and plan to continue to offer these short webinars. Our webinars are recorded, so if you missed part of the Q&A or want to go back and hear that part again, it will be posted on the Data Practices Office YouTube page soon. Today's webinar is the third part in our 5-part series on law enforcement data. If you missed the first 2 or would like to revisit them, I will show you how to find those videos on our website, which is the link on this slide. Note that many of the things that we discuss in our webinars are also on our website. So for law enforcement, under types of data, you can see body cameras here. If we click on law enforcement, you can see a variety of topics here. In terms of finding our YouTube channel, you can always find it in the footer down here. Or if you go up to news and events under webinars, we have a link to our YouTube channel right here. And if you're having audio troubles, there is a document on audio FAQs. So if we click on this link and go to our YouTube channel, you can find our videos here. You can see the playlist for the law enforcement series and the personnel data series that we did recently. We also have one on the open meeting law. If you go up here to videos, you can see all our videos. We have videos on social media, licensing, and other topics. Also, right here, we recorded a webinar on data practices and the open meeting law during the COVID-19 state of emergency. So that might be a good one to look at if you have questions on that. If you'd like to download a copy of today's PowerPoint, I am going to share it right here. I'll also do this later in the webinar for those who join later or miss it this time around. A pop-up window should have appeared, and then you can select the file and download to your device. Today's webinar is going to be a very high-level review of various provisions that impact law enforcement data practices responsibilities. They are fairly wide-ranging and may seem somewhat unconnected, but they are provisions that come into play as law enforcement agencies respond to requests for information, and there are provisions that we often get asked about. As usual, we will leave some time for a Q&A session at the end of the webinar, so please feel free to send in your questions as you think of them using the Q&A panel on your screen. When sending in questions, please send them to all panelists so we can be sure to see them. All right, we are going to jump into the miscellaneous provisions, starting with some provisions in Chapter 13 that we haven't covered, and then move to some outside of Chapter 13. 911 calls. There's a separate provision in Section 1382 about 911 calls. Subdivision 4 makes the audio recording of a 911 call private data on the caller. A public requester can ask for a transcript, and unless there are any protected identities, which we talked about in the first law enforcement webinar, then the transcript is public. This provision came from a situation where a family heard a distressing 911 call on the radio reporting the deaths of other family members before they had been notified by the authorities. The family went to the legislature, which then added this language. And this is another example where we see the legislature weighing the difference between data that are in writing versus data that are audio or visual, and providing different access based on that distinction. This subdivision also allows for some sharing and use of that private audio recording in certain circumstances, for instance, for training. Property complaint data, Section 1344. The identities of individuals making complaints about the use of real property are confidential. As you know, confidential is the most restrictive classification, which means that data subjects do not get access to data about themselves. This means that if I make a report to the police department about my neighbor using his backyard to burn garbage, and then I request a copy of that report I made, technically that is confidential because I've identified myself as the complainant in the request and I can't get access to the complaint. In general, when requesters ask for complaints related to certain addresses or blocks, they can have access to the complaints as long as the complainant's ID is not discernible. I've referenced Advisory Opinion 08003 on the slide, which talks about withholding data that identify the complainant. Remember, as we mentioned in the first law enforcement webinar, identity is more than a name or address. It is also characteristics and context. Often these complaints arise between neighbors, and to the extent that the complaint itself identifies the complainant, then those data should be redacted per 1344. The complainant has to be complaining about violations of state law or local ordinance about the use of real property for this section to apply. There are a couple advisory opinions that talk about the use of real property, including noise from children in a swimming pool and odors emanating from a wastewater treatment plant. The Commissioner concluded that both were uses of real property. Very briefly, the other provision in Chapter 13 that we want to mention is Section 1343, which is personnel data, and its intersection with 1382 law enforcement data. We have a whole webinar series on personnel data, which I noted on our YouTube page. But for law enforcement, it's important to note that when there is a law enforcement employee who may also be involved in criminal activity, the same data may be used in both the criminal investigation and the personnel investigation. If a public data requester asks for public law enforcement data, and those data are the same or similar as the data used in an open personnel investigation, the public law enforcement data cannot be withheld as private personnel data. The reverse is also true with public personnel data that might be in an active criminal investigation. I've noted some advisory opinions that you can take a look at that discuss the intersection between these two provisions and when public data has to be provided, even when it might be used in another kind of active investigation. Turning outside of Chapter 13 for a moment, Minnesota Statute Section 16909 requires law enforcement for some crashes to forward an accident report to the Commissioner of Public Safety. Generally, the public cannot get an unredacted copy of the state accident report. Only the people listed in 16909 Subdivision 13 can. Those would be people with a legal or financial interest in the crash and are listed on the slide here. The statute allows the Department of Public Safety to charge $5 for a report. However, local law enforcement providing a copy must adhere to the Chapter 13 copy cost structure, so that's going to be 25 cents a page for paper or actual costs for electronic copies. Some law enforcement agencies only fill out the state crash report as documentation of the agency's response to a particular traffic accident. Other agencies have both their own incident report and the state crash report. For agencies that only have the state accident report, they still have the obligation to provide public law enforcement data documented in the report upon request. Section 16909 includes a provision that says there isn't a penalty for providing request for service or response or incident data from the state accident report. Those are the data that are classified as public under 1382 subdivisions 3 and 6. For those agencies that have a separate incident report in their own record-keeping system, there's no obligation to provide a redacted state crash report to the public. They can just provide their usual incident report. So let's look at a couple scenarios involving accidents. We have an adult driver who ran into a fence and caused damage. The property owner asks the local PD for the state accident report, but the PD tells her to get it from DPS. What should law enforcement release? This property owner suffered a loss and so has access to the state report under 16909 subdivision 13. And that provision also says, upon written request, DPS or any law enforcement agency shall disclose the report to the parties listed in subdivision 13. So the police department should provide the report to the property owner. Again, the property owner is not a member of the public here. The property owner is somebody who suffered a loss and is specifically listed in subdivision 13. A member of the public saw a car crash near his home and asked the sheriff's office for public data about the accident. What should law enforcement release in this situation? Because the requester is a member of the public here, if the state report is the only documentation of the law enforcement's response to the accident, then the sheriff should provide the 1382 subdivisions 3 and 6 data, request for service or response or incident data, and redact everything else. If the sheriff's office maintains a separate incident report, then the requester would get the public data in that report and would not have access to the redacted state accident report. Moving on to maltreatment investigations under 626556 and 626557. There is broad authority in these sections to share not public data and public data between and among the agencies responsible for various aspects of child and vulnerable adult maltreatment investigations. This includes law enforcement sharing with local social services or vice versa, or the other agencies that are responsible, including the Department of Health, Department of Human Services, Department of Education, and vulnerable adult review panels. We are recording this at the end of July of 2020. Starting next week, the provisions of Section 626556 will be found in Chapter 260E. In the first special session this year, the legislature recodified the provisions of 626556 into its own chapter. So just be aware of that change. The data practices provisions will now be in 260E.35. Last year, the legislature added a new requirement for law enforcement to notify the licensing boards for teachers, principals, and superintendents if a licensee has been found to abuse a student. So right now that's in 626556, subdivision 10, but it will be in 260E.20. Driver's license data. The Federal Driver's Privacy Protection Act, or the DPPA, prohibits the sharing of personal information obtained through motor vehicle records unless there is a permissible use. The law then provides 14 broad permissible uses. Minnesota law requires that data provided to obtain a driver's license or to apply for a driver's license be treated the same way as provided in the DPPA. So one of the permissible uses under the federal law is if the personal information is disclosed for use, quote, by any government agency in carrying out its functions. There's another permissible use that says that the data can be disclosed for any other use specifically authorized under state law if the use is related to the operation of a motor vehicle or public safety. So compliance with the Data Practices Act is arguably a function of all government agencies in Minnesota, including law enforcement, and responding to data requests is required by law. So generally, there is a reasonable argument that if law enforcement is auto-populating incident reports and citations directly from the DVS database with what would otherwise be public data, response or incident data, for instance, the agency can provide those auto-populated reports in response to a public data request. If you're interested in this topic, we don't, as far as I know, we don't have any case law in Minnesota addressing the intersection between the DPPA and the Data Practices Act. There was a case in Wisconsin in 2016 with the city of New Richmond where the Court of Appeals discussed the analysis of the Wisconsin state records law and the DPPA and kind of the intersection between the two. So that is the city of New Richmond case from 2016 out of the Court of Appeals in Wisconsin. Occasionally, we receive questions from law enforcement agencies asking about whether certain medical information is protected by HIPAA. In order to be covered by HIPAA, an agency has to be a covered entity, which is defined under that federal law. And that would be a health plan, a healthcare clearinghouse, or a healthcare provider who transmits any health information electronically related to payments. So generally, law enforcement is not a covered entity and not subject to HIPAA. There may be some narrow exceptions, including if a law enforcement agency has its own group health plan, certainly that health plan is subject to HIPAA. And there are some questions related to EMT services. But generally, a local PD or sheriff's office doing its law enforcement work is not subject to HIPAA. The medical information that law enforcement officers observe and record is generally going to be classified by the Data Practices Act. And at this time, there isn't a general not public classification for medical data as maintained by law enforcement. We do have in Minnesota the Minnesota Health Records Act. And that says that it has a provision that says that a person who receives a patient's medical record directly from a provider may not disclose that record without statutory authority or consent. Okay. We're going to look at a couple examples of just applying these principles. Okay, is this a medical record? An officer takes a photo of the contents of a medicine cabinet. A deputy notes that a suspect uses an inhaler. Is this a medical record? No. The photo and the note are law enforcement data classified under 1382. The law enforcement agencies are not subject to HIPAA. It is not a medical record directly from a provider. It's law enforcement data, and the classification is going to depend on whether there's an active investigation. A law enforcement agency gets consent from a victim to retrieve records from the hospital to determine the extent of her injuries. Is this a medical record? Yes. This record came directly from a provider, the hospital, and is now maintained by the law enforcement agency. So the Minnesota Health Records Act applies, and even when the data become inactive criminal investigative data, law enforcement should not disclose that specific record without specific statutory authority or consent. And you can see that in 144.293 of Minnesota statute. Criminal background checks. Law enforcement agencies are often contacted for criminal background checks, and we occasionally get questions from law enforcement on what they should provide. These checks are required for certain positions, like becoming a police officer or a coach at a school, or if someone wants to run a daycare or become a foster parent. Those checks, as maintained by the requesting agency, are generally private data, so the data subject is going to be able to have access, but the public cannot. If law enforcement gets a request for this type of background check, they can provide public data. If the requesting agency also has consent from the subject, law enforcement can also provide any private data, which would include any juvenile record the data subject may have. However, the requesting agency would not get access to any active criminal investigative data pursuant to criminal background check requests unless they have a specific statute that says they can. Finally, back to Chapter 13. Section 1337 includes a provision for security information. Security information is a broad authority for government to classify otherwise public data as private or non-public in circumstances where there is a safety or security issue. Because this authority can be very broad, the threshold is high. The disclosure of the data has to be likely to substantially jeopardize the security of people or things. So the substantial jeopardy has to be likely as a result of providing public data. The legislature made it clear that this is a fairly high hurdle, and entities should consider the use carefully and be able to provide an explanation upon request. Classifying data as security information should be done on a case-by-case basis. The circumstances and context make a difference, so there may be a safety or security threat at the time of a request, but down the line the circumstances have changed and the data go back to being public and accessible. In addition to any otherwise public data, security information specifically includes checking account numbers, crime prevention block maps, identifying information on volunteers who participate in community crime prevention programs, and GPS system locations. All right, so that was a very high-level review of miscellaneous provisions that law enforcement agencies might encounter while fulfilling their data practices obligations. We have time for questions now, so please send them to all panelists in the Q&A panel. While you're thinking about your questions, We just want to highlight the work of another office at the Department of Administration, the State Demographic Center, which is leading the work for the 2020 census in Minnesota this year. A good census is the foundation for a fair democracy, and we know that you all want to be counted and the folks that you work with and serve want to be counted as well. You can learn more or direct people to the website listed here. This is going to allow Minnesotans to keep our representation in Congress and receive the funding for needed services. I am going to put up the PowerPoint again. And if anybody needs to grab a copy, they can. Again, please send in your questions and we'll respond to them shortly.
All right, so we have a couple questions already. If you hear any silence, it's just because I'm reading the questions. Your sound is okay. So the first question is, why a complainant cannot have access to their own statement about property use complaint under 13.44? Usually a complainant has access to their own statement and other provisions. So the reason why property complaints are different is under 13.44 property complaints, the identity of the complainant is classified as confidential. The legislature used a confidential classification, which means the data subject does not have access to their own complaint. If the legislature had used a private classification, they would have had access, but here it's just because there's a confidential classification. We have another question that says, your example showed you got consent from a party to get medical records on them. The answer was that it is private and cannot be released. I thought if consent was given, then it is okay to release. So in that example, the informed consent was to receive medical records or obtain medical records from the medical provider directly. Informed consent to then subsequently release those records would be different. So a law enforcement agency obtains informed consent from someone to get access to their medical records. Once they have those records, they would then need informed consent to release the records.
We have a question about security information under 1337, asking about how it's determined in terms of the time component by the date of the request or the date of the document. So data access is determined at the time of the request. For security information that is just generally public, not those specific ones that are laid out like checking account numbers, if it's just presumptively public data, that disclosure would cause a security or safety issue for someone. That's assessed at the time that you receive the request. So the data are just sitting out there public, nobody's asked for it. Once somebody's asked for it, you take a look at it, you take a look at the situation, and you make the decision at that time. If you get another request for it a month or a year or 2 years later and the situation has changed, maybe it's fine, maybe the security issue is not there anymore, then you can just give it out as public. So you make that decision at the time of the request.
We have another question that says, juvenile info on criminal background checks can be given out with written consent from the individual. Please clarify. So I think what this meant was when somebody gives their consent for a background check to be conducted on them, that informed consent can cover the private data on themselves. And so the juvenile justice data that the law enforcement agency has on the individual would be private on them, and that could be released with informed consent. We received a question on juveniles, but our next webinar in the series is going to cover juvenile justice data. So I'm going to wait to address issues on juveniles until we do that webinar. If you have questions in the meantime and want to give us a call, feel free to do that.
We have a question about releasing, can medical records be released to an attorney's office for charging purposes? I think that in terms of providing data to prosecutors for charging decisions, law enforcement can provide all the data that they've compiled to the prosecutor because the prosecutor is really acting as an agent. There's sort of an agency relationship there. So I think that that record, is obtained generally to help with the charging decision. So yes, that can move with the rest of the data that the attorney would be reviewing. Yep, so we have another question about background checks, and this is about when somebody is applying to go into the military. This is a fairly common question that we get from law enforcement. Usually when somebody is going into the military, they have signed a consent form saying that they can, that the military can get their records. And so if you have any private data about that individual, including their record from when they were a kid, that can go with informed consent because private data can move with informed consent or be disclosed with informed consent. The things that you want to consider are you might be getting the consent form from the military. So you can say, I prefer if you use this city or county consent form that we have, you could get the data subject to sign that, or you could look at the military's consent form, and if it hits all the factors that are required in Minnesota, then you can certainly take that. The other thing is generally people know what they have done in the past, or if they have a juvenile record, they might not know that in giving consent that they are allowing that record to be disclosed. You don't have to, but you can contact the data subject and say, just so you know, your juvenile record is going to be disclosed because you've given consent. But you don't have to do that. That's something you can consider doing. All right, these are great questions. We have just a little bit of time left today. So I just want to give some time in case there are any other questions. If you did not hear your question, we will follow up with you, or feel free to give us a call or drop us a line. Again, we have just a few more moments. So if you have a question, let us know. All right, it looks like everyone has had a chance to ask a question. So again, please feel free to contact us if you think of something later on. That's going to be our time for today. As I said, this webinar is recorded, so you can certainly go back and listen to those questions that were asked and our responses. Please provide us with feedback on the survey that will pop up after you exit WebEx. Stay tuned for the Gov Delivery Notice for Part 4 of our law enforcement series, which we noted is going to be on juvenile data. If you have any requests for other topics for data practices or the open meeting law, let us know so we can cover those for you in the future. Thank you for joining us, and take care, everyone.